All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in ceremonial session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good afternoon. Welcome to the 2015 final round of the Florida High School Moot Court competition. We are grateful for your interest in the state courts and the appellate process. And thank you to all of you and the students who wrote and submitted briefs this year, and to the teachers and attorney coaches and judges who assisted throughout the process. Following the oral arguments today, we will then retire to the conference room to discuss the outcome for a few minutes. We will not announce our decision. Then we will return to the bench for photographs with all the teams. After photos, we will have a tour of the court for the teams, followed by an early dinner and awards program over at the Governor's Club. In our case today is Harper Sanders versus Everglades Computer Inc. and Chartec Tech Services Inc. And are both teams ready to proceed?
Yes, Chief Justice.
Okay, and let's hear from the petition.
Chief Justice LaVarga, may it please the court. My name is Emma Perez. My co-counsel is Devin Barkey, and together we represent the petitioner, Ms. Harper Sanders, in today's case. Of the two issues before the court today, I will address the first issue of invasion of privacy, while my co-counsel will address the second issue of interception of communications. At this time, we would like to reserve 2 minutes for rebuttal.
Absolutely.
There are 3 reasons this court should reverse the decision of the 6th District Court of Appeal. First, respondents acted as state actors. Second, as state actors, they did not serve a compelling government interest or use the least intrusive means in furtherance of this interest. And third, Ms. Sanders did not consent to the actions of the respondents. Now, the right to privacy is a right with strong protections, both at the federal and state levels.
Can I ask you a question?
Of course.
These, the equipment here was known to have come from the state actor, correct?
The equipment came from the respondents to private companies that entered in.
But it came through the school, didn't it?
Yes.
All right. And if it comes through the school, and you've got all these different people there involved with that, and the way technology and all of its fingers go these days, why would it not be reasonable to assume that this petitioner was well aware that there was no privacy involved here? I mean, look at all of the equipment that I don't even know the name of it that exists, that records all of this stuff and information. Why is it reasonable to assume under this circumstance, not the petitioner's own equipment, but equipment obtained from the school, that the school would not, or someone else would not have access to this?
To answer your question, Justice Lewis, we must address the issue of consent. In the state of Florida, consent must be given knowingly, willingly, and voluntarily. In this case, the respondents released several pieces of promotional material along with a lease agreement to the students of Palm County High School, the school which the petitioner attended. In this promotional material, the respondents assured the students that the computers, which were property of the companies, were to be safe, private, and secure, as reflected on page 26 of the lower court's record. Respondents only said that the computers could be remotely activated, but did not explain what exactly remote activation entails.
What about the fact that they signed a monitoring form, correct?
This is true, Justice Quince.
And in that monitoring form, it said that they would be activated remotely. And so why isn't that enough notice to the petitioner that this might happen?
To answer your question, Justice Quince, in this case, the respondents used enhanced capabilities beyond that of remote activation. Remote activation typically entails the use of geolocation technology, such as IP and DNS, two capabilities which the theft track system possessed. However, they went further and used screenshot and webcam capabilities.
Well, was there any indication in the monitoring form that only one form of monitoring would take place?
Justice Quince, on the monitoring notice, there was no indication as to what type of monitoring would be used. It simply said that Ms. Sanders would authorize the respondents to use the theft track software apparatus. It did not indicate what that entailed or that it could take pictures of whatever was in front of the computer or what was on her computer screen.
Isn't the problem here that, and maybe it isn't a problem, that we're assuming right now that they're state actors, but it was a private company. And it looks like what happened is that there were individuals within that private company. How many minutes? Okay. Individuals within the private company that went beyond what the intent was for theft track. So the school, don't you have to show that the school agreed that the monitoring could be greater than what was needed to track stolen devices, or is that part of the invasion of the state actor? Do you not understand that? In other words, what if a teacher, without the knowledge of the school, was peeping into the girls' locker room, invaded privacy? Is that, but the teacher, it's one thing, but the school, when you sue the school doesn't know that's going on. Do you see any distinction between whether the school knew about the extensive monitoring that was going to take place?
Justice Periente, your question deals with the state actor component of our argument. Although the respondents did go outside the scope of their contract with Palm County High School, which simply entailed that they were to provide the computers to the students, provide technical support, and track lost or stolen units, they can still be held liable as state actors. The United States Supreme Court decided in West versus Atkins that state employment is generally sufficient to render a defendant a state actor. In this case, the respondents were state actors, as they provided a service that a school would normally provide, providing educational equipment to the students, and were compensated for this service. Although they went outside the scope of what the school expected them to do, they can still be held liable, as this court ruled in Edwards versus Wallace Community College. They used the power that was delegated to them by a state authority to invade the privacy of Ms. Sanders along with the other students.
Isn't the case here that they're using authority that they derive from the contract to which they're a party and to which the students are a party? So the basis for their action is that contractual undertaking. Isn't that correct?
Justice Kennedy, there was a contract between the students and the respondents, which was the computer lease agreement, but additionally, there was a contract between Palm County High School and the respondents, as indicated on page 21 of the lower court's record. With this contract, this contractual obligation between the two parties, the respondents used the power that was given to them by the state, the power to interact with the students to provide the tools to open the doors to the future, and use this to violate their privacy.
Now, how can there be, I understand your argument up to a certain extent, but at some point, the petitioner knew or suspected that something improper was going on. And instead of going and reporting it to the school or taking other steps, they decide they're going to play a prank. So how then, under the facts of this case, why would they have a reasonable expectation of privacy if the very prank that they are now complaining about that went bad for them was the basis for their cause of action? In other words, how is it that they should have a reasonable expectation of privacy if they knew and actually committed acts in order to sort of play a prank?
Justice Periente, having a suspicion that someone is invading your privacy or that someone is watching you does not completely eliminate a reasonable expectation of privacy. Simply because Ms. Sanders believed that someone, she did not know who exactly, was watching her, does not mean that she did not expect the confines of her bedroom and her private computer, which the respondents assured her would be safe, private, and secure, to be private. And
What if she decided she saw somebody that was watching, and she thought, and she took off her clothes? I mean, she did it to say, well, let me see if somebody's going to watch me. Isn't she actually exposing herself literally to what then followed?
Justice Periente, she did not waive her right to privacy through her conduct. As Justice Scalia said in Gonzalez versus United States, fundamental rights, such as the right to privacy, cannot be waived without explicit and knowing consent. Ms. Sanders did not know who was watching her, nor did she know that the webcam could take pictures of her. Perhaps she believed that the microphone on the computer could track what she was saying or what she was doing on the computer, but she didn't know that the webcam could actually take pictures of what she was doing, as respondents did not disclose this information to the students of Palm County High School. As for the issues of compelling state interest, least intrusive means, and consent, we rest on our brief. I see that my time has expired. May I briefly conclude?
Go ahead.
For the aforementioned reasons, we ask that this court reverse and remand the judgment of the 6th District Court of Appeal in order to issue a judgment in favor of Ms. Sanders. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court. My name is Devin Barkey, and today I'll address the second issue, the interception of communications in violation of Chapter 934 of the Florida statutes. There are 3 reasons why this court should reverse the decision of the 6th District Court of Appeal. First, the plain language of the statute and the case law accompanying Chapter 934 makes it clear that when a screenshot is taken of e-messages, it constitutes interception of electronic communications. Second, the tracking device exclusion in this case should not be applied, and if applied, it still does not exclude the communications in this case. Third, there was no consent on the part of Ms. Harper Sanders to the interception of communications that occurred. The plain language of the statute and the case law accompanying Chapter 934 explicitly says that when a screenshot is taken of e-messages, it constitutes interception. The 5th District Court of Appeal, in its decision, O'Brien v. O'Brien, ruled that chat conversations, instant messages, and emails are beyond doubt electronic communications under Chapter 934.
Let me ask you here, your contention is that there's an interception of a communication to fall within the statute. Who is communicating with who? To have a communication, you've got to have a sender and a receiver. So who is the sender and receiver of the communication here that is being intercepted?
Justice Kennedy, the 2 parties to this communication were the petitioner Harper Sanders and her friend Robert Michaels. They exchanged e-messages through their computers that were given to them by the respondents in this case.
So the setting up of the fake drug deal, and also, of course, there were other things that I thought it was a he, it was she. What are marshmallow peeps? Do we know what that is? Uh-oh.
Your Honor, she set up marshmallow peeps in order to share with her friend.
But I don't know what that is, so you have to explain that.
She would set up little candies and set them up to look like certain movies that were occurring. She did this to share with her friend Robert Michaels as sort of something fun to do with the computers. But we do not contend that any pictures taken by the theft track program were electronic communication.
So it's only, because that seems to me pretty outrageous, and I guess that's under the first count, the invasion of privacy.
Yes.
But so the only part, we're really drilling down, it seems that there was a lot of interception, but the only interception that you're saying actually falls under the statute is exactly what? What was it that occurred between the 2 friends? They were sending messages back and forth that said what?
Justice Periente, they exchanged e-messages which were relating to the drug deal that you talked about earlier. Furthermore, the court in O'Brien v. O'Brien said that when a screenshot is taken of those communications, it constitutes interception under Chapter 934.
What about the photograph of the fake drug scene?
Your Honor, the ruling in Minotti v. Botto, we believe, is holding in this case, and that there is no substance of communication in any of those pictures that were taken.
So you don't want to argue that that case was wrongly decided?
No, Your Honor, we believe that that case was rightly decided as they relied heavily upon federal decisions which all ruled that silent video surveillance is not covered. And thus, by pure logic, it is true that still images which do not detect as much as silent video surveillance are not covered as well. We only contend that the e-messages exchanged between Harper Sanders and Robert Michaels were electronic communication. And that is clear by the ruling in O'Brien, which said that these type of communications are beyond doubt electronic communications. With regards to the tracking device, this court in 1984 ruled in the case Burgess v. Burgess that the common law spousal tort immunity should not be applied to interceptions under Chapter 934. This court did so for two reasons. First, it would undermine the legislative purpose of the statute to protect every citizen's right to privacy in his or her communications. Second, it would result in an equitable operation of the statute. The same rationale in that case applies here. If this court were to exclude all communications from any device which permit the tracking of the movement of an object or a person, it would undermine the purpose of the statute, which is to protect every citizen's right to privacy. All our communications today, whether through our iPhone, iPad, or other tablet or other laptop, would be excluded from protection under Chapter 934. The court in O'Brien wrote that the purpose of the act is to protect every citizen's right to privacy.
I guess and maybe this is a friendly question, I'm trying to understand, I'll do it in the instant messages, right? You send a message and you say, I'm leaving my house without my parents' permission at 9 o'clock, okay? And it's sent to someone and someone else intercepts that. That's a communication. But if I send a photograph showing me leaving, that's not a communication?
Justice Periente, that is communication.
So wasn't, that's why I'm trying to understand, when the photograph was, when the transmission of the image between the two friends, when it went from one to the other, why wasn't that also an interception? That's different than Minotti.
Your Honor, the two students did not exchange any messages. Certainly images that are sent by two parties are communications.
Okay, so she couldn't, the one on the other end did not see what was going on with the fake drug scene?
No, Justice Periente.
Okay.
The picture in this case was captured by the Theft Track program, and then it was sent to the respondents in this case. And
Let me
thus,
ask you this. Was this the computer that was being used, was this the same computer that this petitioner had reported as stolen or missing somehow?
yes, Your Honor. On March 26th, she did report her computer as stolen.
And so by doing that and signing some kind of form that said that this was a lost computer, wasn't she inviting this kind of monitoring? Because she clearly knew that when you report, I mean, if the thing is stolen, that they're going to be on it, trying to track and figure out where it is. So it seems to me that to some extent, your petitioner has invited these people to monitor and try to figure out where this computer is. Hadn't she?
Justice Kinsey, the monitoring notice had the same vague language as the contract that she signed that reported her computer as lost. It did not indicate what methods would be used to track her computer. A reasonable person would not know that remote activation or whatever language that were used in this contract would...
What language did the contract use? As I understand it, said monitoring and tracking.
Your Honor, it said remote activation and that the computers had a shared link with Everglades. We submit to this court that a reasonable person...
What do you think a reasonable person would interpret remote activation as being?
That they would be able to remotely activate the computer if it is turned off, and that they would be able to use any geolocation services that that computer has. Certainly, the term remote activation does not indicate that these respondents could take pictures of the petitioner's bedroom and that she could intercept their communications. This brings me into my third point, which is the...
If you're trying to determine where this supposedly lost or stolen computer is, it seems to me that you're inviting them to do whatever is necessary to try to determine what this location is where they're now found the computer.
Your Honor, the screenshot and the webcam images were tertiary to the DNS and IP tracking. The IP and DNS tracking could find the location of the computer. The two other methods, the webcam and the screenshot, could not find the location of the computer. They could perhaps identify the person with the computer, but that would not in any way help them find the computer. With regards to consent,
Well, it might if it showed the face of the person who had reported it as stolen, wouldn't it?
that is correct, Your Honor. However, it would still not be able to determine the physical location of the computer. Your Honor, I see that my time has expired. May I briefly conclude?
You may briefly conclude.
We respectfully request that this court reverse the decision of the 6th District Court of Appeal because Ms. Harper Sanders' communications were intercepted in violation of Chapter 934. Thank you.
Thank you. Counsel?
May it please the court? Chief Justice Lombarga, Justices, opposing counsel, my name is Sarah Frunskevich. My co-counsel, Nathan Vidal, and I will be representing the respondents, Everglade and Chartec Tech Services. I will be addressing question 1, and my co-counsel will be addressing question 2. Question 1 asks this court whether or not the respondent's utilization of webcam and screenshot monitoring violated the petitioner's rights under Article 1, Section 23 of the Florida Constitution. We ask this court to uphold the 6th DCA's decision where it determined that Everglade was not a state actor. However, if this court does find it doubtful that Everglade is not a state actor, they still cannot be found to have violated the Florida Constitution because they had the petitioner's consent to collect the information that they did.
But really, all on the second part, if you consent to a tracking, if it's lost, it's one thing, but over time, it says the employees began to hold viewing parties to watch the petitioner. That certainly was not within the scope of her consent in any reasonable way, and that was done even before there was any issue of the computer being stolen.
Yes, Your Honor, and in that case, that was the employees taking actions on their own, not Everglade as the company as a whole doing these actions. So as for Everglade as a whole monitoring the student, they had the consent to collect the information.
So you're saying, and again, this is hard because we got to limit the issues, that actually this is a situation of the employees acting outside of the scope of what they were supposed to do, and neither did Everglades know this was happening?
Everglade did not know that this was happening.
Well, I mean, the record doesn't really establish that, though, does it?
It does not. The record does not reflect whether or not they knew until the CEO was confronted with certain images that a employee showed him.
But why aren't they a state actor? The computers are state computers, and instead of the computer, the state or school computer experts going and putting this technology into place, they contracted with somebody to do it for them. So why aren't they state actors under that circumstance?
Your Honor, as the opposing counsel themselves said, the computers were property of Everglade itself, not the state. So they were not state computers. They were Everglade's computers that they were providing a service with.
Well, what happens with it was only through the school that these were placed in the possession of the users, wasn't it?
That is true. However,
Go ahead.
To be determined a state actor, as found in Edwards versus Wells Community College, a entity has to be acting with state power or authority. In this, there's no denying that the school was involved in this case. However, they did not give Everglade any state power. And we argue that state power is any sort of power that a person or entity would not have unless they were part of a government.
Well, weren't they doing this because, I mean, let's face it, schools don't have, unlimited resources. So in essence, they were the school giving the equipment to the students, weren't they?
That is true, but to provide educational tools for students, opposing counsel has argued that that is a state power. However, that is not true. There are many private websites and companies that provide educational opportunities for students to use. However, they are not affiliated with the state in doing that.
Well, that's different. On their own, the students go and start to use other applications, and maybe they download them on their computer. I don't know if the schools allow that. And then those other entities somehow do something that's different than this is directly how the school made these computers available, and the school required them to consent to tracking, but not to the interception or the monitoring of private communications.
Your Honor, you said that they required the students to do this. However, the record reflects that the one-to-one program was an opportunity that the students could take part in. It was in no way required. If a student wanted to lease a laptop, then the school would be a medium through which they could do it with Everglade, but the school was not requiring students to do so, and the student had the choice whether or not they wanted to participate
Well, but again,
in
now
this.
you have an economic disparity, because somebody might be able to have their parents provide a computer, but for those that didn't have the wherewithal, they are using a school, in their minds, a school-provided computer. Did the students have to pay anything?
If they wanted to take the laptop off of school
But if
property,
they wanted to just use the computer, did they have to pay something to the school?
the record does not reflect that they had to pay anything unless they were taking the laptop off of school property, which at the end of the day, they would have to pay a $60 deposit fee, which in this case, the petitioner did not pay consistently as she took the laptop off of the property. Therefore, the laptop was labeled either lost or stolen as it was not accounted for. That brings me back to consent. Because the petitioner signed a monitoring notice and eventually a lost form, and then continuously took off the laptop off of school property without paying a $60 deposit fee, the laptop was clearly labeled lost and/or stolen.
Did the school or the company confront Ms. Harper about not paying the fee? Or I'm not sure I understand quite why the non-payment of the fee has any bearing on whether or not these companies invaded her privacy.
It is relevant because when the laptop is not accounted for at the end of the day, when a $60 deposit fee is not paid, but the laptop is missing, it's either stolen or lost. And the monitoring notice states that if the laptop is lost or stolen, then remote activation will occur to
Okay,
help.
but this is really, maybe you just take it like you find it, the weakest argument, because after she doesn't pay the fee, instead of taking the computer and requiring her to bring the computer back, what do the employees start to watch her doing these little skits. And then even when she reported it missing, the next day she told her teacher it had been found. So in terms of not paying the fee or reporting it missing, if it was really missing, those employees should have taken steps to get it back, not watch what this person was doing over a several-week period of time.
The issue with that is the defendant did bring, the petitioner did bring the laptop back to school on multiple occasions. However, then they also took it off again on numerous occasions. So every time that this student took the laptop off, even if they saw the photos again of it being the same person again, every single time the laptop is taken off does not necessarily mean the same person is taking it. So every time she took it off without paying the deposit fee, then they assume.
Wasn't there a simple remedy for that? I mean, if you're not paying the deposit, then you take the computer away, right?
Well, the record does not reflect if the the school was Everglade was providing a service with the school to provide students with laptops, and the record does not reflect if they were bound to continuously offer it to students who failed to pay the deposit fee.
And here's the problem. If Everglades thought it was stolen, they needed to take steps to let the school know it was stolen, rather than watch what she was doing in her bedroom. And if the only time they ever notified the school was after they watched this fake drug deal, which occurred way over weeks after everything else had occurred. Isn't that what the record shows? That the time when they finally told the school there was something going on, it wasn't about the stolen computer, it was about they thought there might be a drug deal.
Yes, Everglade did that because they were concerned about the possible drug deal going on.
But they weren't concerned before that about the computer being stolen, were they? I mean, is there anything in the record to indicate that's what they were concerned about?
The concern of Everglade every time they turned on tracking was to find their laptops and ensure that they were...
But once they found the laptop, they never reported to the school. I think that's what the justice is trying to say. I mean, how many times did they determine that the computer was stolen? At least 8 or 9 or 10 times, and they did nothing until they saw this fake drug deal going on.
Everglade was not required to inform the school that the laptop was lost or found. It was for their own information as to where it was. I'm
So
sorry.
that's a pretext for you can just surveil as long as you want to, as long as you know where the computer is, you can continue to. That would obviate the purpose of the monitoring, was to track lost or stolen computers. So they found it, and now they're voyagers. Huh?
I'm sorry, I didn't word that well. To find the laptop, the tracking was turned on numerous occasions. The record does not reflect if, once they were collecting this information, if Everglade knew exactly where the laptop was at the moment. However, the student was constantly bringing the laptop back and then taking it out. So every single time she took it out, it was assumed stolen, and then theft track would be turned on. And again, we ask this court to uphold the 60 CA's decision and rule that Everglade did not violate the Florida Constitution under Article 1, Section 23.
Thank you, Counsel.
May it please the court. Chief Justice Labarga, Justices, opposing counsel. My name is Nathan Vidal, and I'll be representing the respondents Everglade Computers and Chartech Tech Services. I will be addressing question 2, which asks this court whether the utilization of webcam and screenshot monitoring violated the petitioner's rights under Florida State Statute 934.
And you agree for that, you don't have to be a state actor.
Yes.
So
Thank
this
you.
is a tougher part that you have, because clearly there was interception, wasn't there?
We would argue that there is not interception under the case law of O'Brien versus O'Brien, which opposing counsel has brought up. So when they talk about how electronic communication under O'Brien versus O'Brien is e-messaging, you have to also look that O'Brien versus O'Brien very clearly says that it's not screenshots that qualify for an interception, but contemporaneous monitoring with transmission. So what this means is that exactly when the message is being transmitted, it also has to be pulled and then intercepted. However, what was happening was instead the transmission was being sent, it was sitting there, a screenshot was then taken, and it was stored somewhere
But I thought
else.
their argument was that that's not the communication that they were concerned with, the still shots. I thought the argument was that they were concerned with the interception of the emails back and forth between the Ms. Harper and Michael.
Yes, the e messages between the two, and that's what we're arguing here, is that the O'Brien versus O'Brien very clearly says that you have to intercept contemporaneous with transmission, which means at the same time that it's being transmitted. So when a screenshot was taken, stored, and then later reviewed by Chartech and Everglade employees, it's not the same as a direct interception.
But
and that
under the 934, they use also the term images. So why isn't even a screenshot of the room, the email, or whatever it is, why isn't that an image that fits under 934?
Because we argue that under the case of O'Brien versus O'Brien, it says that, quote, electronic communications, in order to be intercepted, must be acquired contemporaneous with transmission, and that electronic communications are not intercepted within the meaning if they are retrieved from storage. So when these are stored and then later reviewed by Chartec and Everglade
So how do
employees-
we know when they actually got the email? We don't know that they didn't intercept the email at the same time that the email was sent.
While the record does not explicitly state the interval of screenshot monitoring, we can safely assume here that the screenshots were not being taken every single time a message was sent, but rather that screenshots were being taken at a set interval and then later reviewed, not being done contemporaneous with transmission.
But isn't that sort of elevating form over substance, which is that the intent of the statute is to protect a person's right of privacy against interception between two people. So the fact that the interception is not contemporaneous, how does that make it any less of a violation?
We argue that it's less of a violation first because
Well, but
of...
again, now you say, if it's a violation, it doesn't matter if it's a little one or a big one, but why does it not constitute a violation?
We argue it does not constitute a violation because, first, O'Brien versus O'Brien again, and second, because as you said that the law is meant to protect people's privacy, it is also on the back half meant to protect people from accidentally intercepting. And that's why the law starts with the first word, intentionally. And so I'd like to look to the intent that was happening here today. So while the statute does not define intent, Black's Law Dictionary gives the definition of intentional as done with the aim of carrying out the act. And Sinestra, the mindset in tort law of knowing that you're committing an illegal act before it can be civil remedies can be collected, clearly shows us that since Everglade and Chartec did not know that e-messaging was going on and then took a screenshot and reviewed it later, there was no actual interception or violation of the law.
But wait a minute now, the intent is the intent to actually intercept whatever it is. It isn't necessarily the intent to violate the statute. I mean, you don't have to know that you're violating the statute to actually violate the statute, do you? If you, in fact, intend to intercept whatever it is you intercept. Isn't that enough to show a violation of the statute?
That is correct. But we argue that Everglade and Chartec had no intent of intercepting communication. Rather than the intent of intercepting communication, they said had the intent of protecting their investment.
What about these viewing parties?
We argue that, firstly, that these are instead the employees acting on their own behalf and not Everglade as a company. And we second argue that this is not a form of communication. Putting peeps in front of a camera does not constitute oral, wired, or electronic communication, so it would not fall under the statute to begin with.
There was nothing being communicated that they were watching?
We would argue that it's not a form of oral, wired, or electronic communication.
What was it?
We argue that it is instead just a showing of peeps dressed up as movie characters. There's no oral communication going on. There is instead just pictures of peeps moving.
Well, maybe they have a peep fetish. I mean, we're invading at least their right to engage in this behavior of, although I don't know anyone who's ever done it, that people dress up their peeps all the time.
And even if that is the case, we just argue that that's not a form of communication, so it can't be intercepted. And on top of that, the
Wait a
opposing counsel...
minute, you're saying that whatever was going on between Harper and Michaels was not a form of communication between the two of them?
We argue that specifically the taking of pictures of peeps or of the bedroom is not communication via oral, wired, or electronic.
But what they're really intercepting is the action that was going on between the petitioner and his or her friend. So you're telling me that whatever was going on, because I have no idea what you're talking about when you say these peep things. But that wasn't a form of communication between the two of them?
We would argue not. We would argue that while they may be using these peeps to engage with each other, it's not a form of
What is a peep?
A peep is a marshmallow candy in the shape of either a bunny or a little bird.
It's Easter candy, right?
Yeah. They're usually around
She was
Easter.
making movies, little...
Yes.
But, I mean, the issue is...
Are the peeps in our record?
What?
Are the peeps in our record?
The peeps are in the record.
They haven't been consumed?
The record reflects peeps.
There will be.
But here, I mean, I think that in looking at the statute, and it's interesting because there are exemptions in the statute for those that intercept if they are part of a telecommunications provider and in the normal course of their operation. But you're not, your company isn't exempted. And it seems that the whole thing that was being done from the time of the communications of the Peep movies were communications between two people. And I don't know why it has to be captured. I mean, it's the monitoring of it, of the communication, that's the violation, isn't it?
We argue that it's specifically the interception of communication.
Well, how were they not, again, when she made these movies,
Yes.
who was she making them for?
She was making them for her friends Michael's.
Okay, and they saw them? Did other people see the movies?
The record does not reflect if other people knew.
So is that the problem that's missing in the case? That if someone else had seen them and they were watching them at the same time, it would have been interception of the communication?
We argue that it doesn't matter if one person is watching or if 100 people are watching. Specifically, as far as the peeps go, it does not, A, fall under communication, and B, that silent surveillance, as upheld by Monanti versus Boato, does not fall under the form of interception of communication.
But there were employees who were watching the peep shows, right?
That is correct.
We really have to make sure that no one thinks the peep shows are what maybe way back when peep shows were.
A different kind of-
I think these are new things.
The record reflects it's specifically the marshmallow candies and not spying on underdressed women.
But that, I'll leave it alone.
On top of this, we argue that electronic communication, one more time, does not fall under this, specifically the e-messages, because there was a tracking of movement, and this was through the use of the screenshots. While you may not be able to tell where or how a computer got from house A to house B, you'd be able to see movement from house A to house B. And I see my time is up, but may I quickly conclude?
Sure.
Again, we ask this court to uphold the 6DCA's decision that Everglade and Chartech did not violate the petitioner's rights under Article 1, Section 23 of the Florida State Constitution, and that they did not violate the petitioner's rights under Chapter 934 of the Florida State Statutes. Thank you.
Thank you. Rebuttal.
To address the first issue of invasion of privacy, but for the relationship, the contractual relationship between the respondents and Palm County High School, as pointed out by Justice Lewis, respondents would not have been able to intercept the communications or invade the privacy of Ms. Harper Sanders. The respondents had a state power to provide educational equipment to the students of Palm County High School. They used this power to then invade their privacy through the use of the theft track software apparatus. Our friends concede that there is no compelling state interest in the use of the theft track software apparatus. Thus, this brings us to the point of consent.
Let me ask you a question about the respondents here. Does the record show whether they received compensation for providing the computers?
Yes, the record does reflect on page 21 that the respondents received compensation for this service. As pointed out by Justice Periente, Ms. Sanders may have consented to IP and DNS tracking, but she did not consent to webcam pictures or screenshot capabilities, and certainly did not consent to viewing parties held by the employees of Everglade and Chartech to boost their morale, as reflected by page 26 of the lower court's record.
Well, does this case, the legal issue, turn on consent, or whether there is a reasonable expectation of privacy? Or do you equate those two as being the same?
Justice Lewis, we do equate these two as being the same, as it is not in contention today that Ms. Sanders had a reasonable expectation of privacy within the confines of her bedroom. Both sides have agreed to this. The issue of consent.
Well, but once you start putting things on the internet, don't we have a different picture we're looking at?
This is true, Justice Lewis. However, the right to privacy as held in CATS is an individual right. It protects people, not places or objects or the means used to communicate. For the aforementioned reasons, we ask that this court reverse and remand the finding of the 6th District Court of Appeal and find that the respondents invaded Ms. Sanders' right to privacy and intercepted her communications. Thank you.
Thank you. I want to thank all of you for your arguments and for the amount of preparation all of you had clearly devoted to this day. Your arguments were excellent, and I was most impressed with the poise all of you have displayed here today. How many of you want to be lawyers out of 4 of you? 2 out of 4, not bad. Maybe 3. Well, given your performance here today, assuming you want to be lawyers, we on the court can rest easy that the future of our beloved profession is going to be in good hands. So let's do this. Let's give these 4 young people a good, solid round of applause. We're going to step back out here in a few minutes. They're going to set up the courtroom so we can have pictures with you. In the meantime, the court is in recess. All rise.